Welcome to the She Said Privacy, He Said Security podcast. Like any good marriage, we will debate, evaluate, and sometimes quarrel about how privacy and security impact business in the 21st century.
Hey, Jody Daniels here. I'm the founder and CEO of Clover Advisors, a certified women's privacy consultancy. I'm a privacy consultant and certified informational privacy professional providing practical privacy advice to overwhelmed companies.
Hi, I am Justin Daniels. I am a shareholder and corporate M&A and tech transaction lawyer at the law firm Baker Donaldson, advising companies in the deployment and scaling of technology. Since data is critical to every transaction, I help clients make informed business decisions while managing data privacy and cybersecurity risk. And when needed, I lead the legal cyber data breach response brigade.
And this episode is brought to you by, where's the ding?
Ding.
Clover Advisors. We help companies to comply with data privacy laws and establish customer trust so that they can grow and nurture integrity. We work with companies in a variety of fields, including technology, e-commerce, professional services, and digital media. In short, we use data privacy to transform the way companies do business. Together, we're creating a future where there's greater trust between companies and consumers. To learn more and to check out our best-selling book, Data Reimagined, Building Trust One Bite at a Time, visit redcloveradvisors.com. I think you're a little giddy because we're recording during our lunchtime.
I am hungry, but more importantly, why were you scrolling the screen when I was reading my intro? Was that just to increase the degree of difficulty?
When did I scroll on the screen?
While I was reading my intro?
I don't remember doing that.
I want to recount on that. We're going to check the tape. That was intentional infliction of make it difficult on my co-host when he's hungry.
I don't remember doing that. I 100% don't remember. So maybe I need some food because I've already forgotten. And now I have a case of the giggles. This is terrible. Okay, let's get on with it. So today we have Darren Abernethy, who is an AdTech and data privacy attorney at Greenberg Traurig. And Darren enjoys nature, animals, soccer, and spending time with his wife and one-year-old son. So Darren, we're so excited that you are here with us today. Welcome to the Sillies.
Thank you so much. It's great to be here. I've listened to the pod for a while now, and I love what you guys create. So it's a real treat when you reached out to chat. So thank you. I'm honored to be here.
See, our silliness is fun.
You have a favorite episode?
Infectious.
It's this episode, right?
And I'm sorry, Justin, you don't know your own intro at this point. I'm going to have to side with Jody on this one, all right? You're reading about yourself, literally, okay?
You know, Darren, while I can say as a guest, that was a wise thing to say as well as a husband, but I'm going to have to respectfully disagree, but...
Yeah, the questions are going to be harder now, I'm sure.
Yes, that's all right.
It's your turn.
All kidding aside. So, Darren, tell us a little bit about your career journey to your role now.
All right. Well, I began by wanting to be the ambassador to France, but no one appointed me to that position after I graduated college. So despite all those French classes and having it as a second major, ended up sticking with the poli-sci training. So I went to law school. I spent a summer with the IRS Office of Chief Counsel, and that was great exposure, but tax wasn't really my passion project, my calling. I did work a summer at a law firm while in law school, and I ended up going to that law firm, a great place called Mintz Levin in Washington, D.C., and I was a telecommunications attorney to begin with, so dealt with cable companies and cell phone providers and licensors of wireless spectrum and network neutrality and things like that, and it was great. Did it for a number of years, and there are aspects of it that are really exciting. There are aspects that I found less so, rate deregulation, things like that. But I really focused in on the sort of privacy areas that I thought, this burgeoning field of data privacy that I thought was really interesting, with some of the geolocation projects we did, or customer proprietary network information, or things of this nature that really I just took a shine to. And this more or less coincided. It wasn't too long after this where you started to have Edward Snowden and things of that nature that just raised the idea of data privacy and cybersecurity to new levels. And so I made a pivot, and after a number of years in private practice in Washington, D.C., at a firm, I decided in a sort of fit of manifest destiny to move west. And I went to San Francisco to get more hooked up in sort of the startup or Silicon Valley or, data privacy and big tech scene. And I did. I ended up going in-house to a company then called Trustee, now TrustArc, first in a compliance role and then as senior counsel there. And I loved that because I was able to sort of, the motto there was, eat your own dog food, I think it was. Like, you build these solutions, these privacy technology solutions, and then we would use them to implement the company's own privacy program using the solutions. And that way you could sort of A/B test and iterate, learn, and understand where customers are coming from. And for me, it was great because I got to take a key role with all the digital advertising tools and industry relationships that particular big vendor had. So that was great for me, and I did that for several years, and ended up, got the itch to go back into private practice, and so I came back to Greenberg Traurig in San Francisco and got to work with some amazing people like Gretchen Ramos and Ian Bowen and David Zatuni and some others who were out there. And it's been, I never looked back. It's been a great experience ever since you asked.
And you live in San Francisco, which is one of my favorite cities ever.
There's some great restaurants and some great views. I live across the bay in Oakland, but I get to work in SF and I look out on the bay every day, and it's an anchoring thing to do.
It is so lovely over there. Now, we talk a lot about ad tech, sometimes on the show, Justin's favorite topic. And out in the universe, privacy universe, we hear a lot of chatter on cookies and pixels and trackers. We also hear a lot about different alternatives. I was hoping you might be able to offer a few examples and what some of these options are and how companies are utilizing them.
Certainly, I'd be happy to do so. And so, yes, there are lots of alternatives and things to think about here. And of course, this conversation doesn't exist in a vacuum, as your listeners will no doubt recognize. We're just now kind of moving past this giant, much discussed scenario about deprecation of support for third-party cookies in Chrome, the dominant web browser globally, where, whereas we were thinking the last several years, cross-site third-party cookies were effectively going to go bye-bye and enjoin their treatment with the Safari browser and and Mozilla Firefox and some other browsers out there. That's how we were approaching things. Privacy Sandbox. We can unpack those, in any detail if you'd like. But suffice to say, in July 2024, it was kind of no, but not so much. Google announced that they're going to go a different direction and no longer deprecate support for cross-site third-party cookies, but instead move to a new approach, a quote-unquote updated approach that elevates user privacy. And instead of deprecating third-party cookies, they're going to introduce a new experience in Chrome that, quote, lets people make an informed choice that applies across their web browsing that they can adjust at any time. Paraphrase on. So we're still sort of waiting on what the details of what that looks like. And I think, indeed, the details of what that looks like will be rather consequential in terms of, does this effectively end up creating a slow road to deprecation of cross-site third-party cookies, or at least reducing the inventory out there of third-party data derived from them that advertisers and others can use, or will it continue, to sort of exist and people do both? We'll see. So details forthcoming on what that new approach looks like. But for now, we know that Chrome will still have cookies, third-party cookies, into 2025 and beyond. So, you asked about some of the alternatives. There are a number of them. How should people think of this? I think of it sort of as many arrows in your quiver of how to deal with these things that are going to be dependent on the size of your company, whether you're B2B versus B2C, your current tech stack, and overall your sensitivity, the sensitivity of the data that you collect, whether you're in a regulated industry, what privacy laws may apply to you, depending on your eligibility under certain laws. There's a lot of different factors that go into it. But if we're to say, all right, what are some of the main alternatives to third-party cookies? I think we'll start first and foremost with, not surprisingly, a first-party data strategy, which is to say, publishers and advertisers, they know a lot about their customers' granular likes and interests based on how they engage with the website or mobile app that those companies have. What do they purchase? what time of day do they shop? What is their imprecise geolocation, so you get an idea of their market. And then there's like zero party data quizzes that a lot of companies put out there. Hey, which Game of Thrones character are you the most like? Answer these questions. And it's like, because you got to know whether you're like Tyrion, or I'm dating myself with these references now, but the idea being that oftentimes you collect information about people through quizzes that they're ostensibly answering things about themselves to match up with a character or whatever, but really you're giving information about your interests and likes, demographics as well. So I think first party data strategies are going to be huge. You've got more content providers who are becoming sort of mini walled gardens, where they require you to register your account before logging in, as a sort of a condition of being able to access the site or app. And why is that? Well, in part because once somebody is authenticated, then it's them, and you can then begin to ascribe potentially certain interests or just actions that they take within your platform to them to infer interests. And so that's a big area we could go on, but that is I think for companies that are in a position to do that, because not everybody has a strong first party presence, but if you do, you're at a real advantage. And also, we should be clear, for the avoidance of doubt, that even though third-party cookies, cross-site third-party cookies used for advertising and other purposes are, sort of slowly going away, first-party cookies are very much still viable in terms of what you do when you set the cookie on your web domain. That was not implicated even in the Chrome discussions that we've been having the last few years. So that's something that's out there, and a lot of companies continue to use that. Other areas, contextual advertising, which is to say, showing ads based on the content of the website somebody is on. This has been historically a very popular, it has been around historically, but what's different is that now it's been sort of turbocharged, contextual advertising, with artificial intelligence, with machine learning, with natural language, capability enhancements, image recognition, things of that nature, to make it much more granular and nuanced than just, sports website, sports app. Like, it's much more detailed and sort of granular than that. CRM-based advertising, customer relationship management, being able to sort of take your customers' email addresses or phone numbers and potentially, without using cookies, upload certain of that information to certain platforms, social media platforms or otherwise, to then match your customers against their customers, to be able to against their user base, to see if there's a match. Then you could show advertisements on that platform to your customers, or you could create lookalike audiences of people who are not your customers but that fit the same rough profile. That's a non-cookie alternative. Likewise, you've got, like, with some of the social media platforms, there's conversion APIs, so-called copies, that are, again, not cookie based, but that allow sort of direct integrations, server to server. I could go on. There's clean rooms where you're matching data sets from different folks. You've got the privacy sandbox remains a viable one that's still going to be, even though that's no longer going to be the full replacement for third-party cookies in Chrome. Google has announced they're still going to be supporting the privacy sandbox, and you've got things like Topics API, where essentially, third-party AdTech platforms will be given a high-level signal about a user's likely interests, likely topic, interests of topic, that can then be shown an ad, and it's all done sort of basically on the browser, doing sort of computation on the browser to figure out what this browser views the most, and then how to send a signal out that would allow others to send advertisements related to that interest, et cetera. So I'll stop there. There's more. I guess the last one I didn't mention that I think is very prominent is also universal identifiers, this idea of taking and hashing an email address or a phone number, and then being able to use that when somebody logs on multiple sites to be able to authenticate and know that it's a common person without having their direct identifiable information. It's indirect, but it's a universal identifier that is at the heart of a lot of these solutions going forward. That was a mouthful. I'm sorry, I'll stop there. But as I said, lots of arrows in the quiver.
There are definitely a lot of different options. Companies are trying to sort through it all. Marketing teams, which one should I use? And then, of course, you have privacy and legal teams trying to figure it out.
Mm-hmm.
Certainly.
So with all of the options that you just described, what questions should privacy teams and legal teams be asking these solution providers?
Say that privacy and legal teams should first and foremost look to maybe modernize their vendor assessments, because it's not your grandma's vendor assessment world anymore. So you've got to be able to ask probing questions about how the new technologies out there work. How do they address consumer privacy? How do the companies that you're going to work with, your service providers, your vendors, contractors, how do they see themselves fitting in within potentially applicable, state or international privacy law definitions? Because these are the things that then are going to inform what contract provisions you have to have in place with them, or, allocation of responsibility among the entities. Sometimes it's different, if you're selling to depends on what you're doing, but if you're selling to a third party, for instance, versus working with a service provider, different obligations would apply. And I think privacy and legal teams also have to be very prepared and up on training staff to understand, how to read vendor questionnaire answers, or how to separate the wheat from the chaff on a lot of this stuff, and how to complete or update risk assessments and data protection impact assessments, and working with companies like Red Clover advisors to come out there and think these things through, and to understand what's acceptable and where maybe they would demand remediations of the other side, or make changes internally themselves, when to run legitimate interest assessments, creating other internal records to justify your working with a new technology solution, and a provider out there that maybe is somewhat of a matter of first instance for your company. So I think, these are all things that these are the questions they should be asking. How does it work? What do you do? What contracts are in place? How long have you been around? How do you solve for this under these legal regimes? And also, I think internal teams should do A/B testing. Just because you pick a solution that you think might fit for you, if you test it out on different environments and it's actually not getting you what you want, then maybe that's enough to say, well, we're going to tweak this, or we're going to go a different direction. So I always tell clients, you have to be prepared to walk away if something isn't working, or if the juice isn't worth the squeeze on what you would have to do on your end to allow for that relationship. So you just keep an open mind, see the information, and work with good advisors like yourselves, and go from there.
So, Darren, you said something interesting there in your answer. You mentioned contract clauses. And one thing I wanted to ask you is, with the situation that was recently in the news with CrowdStrike and Delta, the contract clauses that surrounded potential liability for, a software update were really in the forefront. And I was curious, with all of the work that you're doing with privacy and security and, around terms for these kinds of providers, but other ones, is that starting to make an impact in what your clients are asking for, or concerns they have about how you protect against the liability? Because you could have a problem with a cookie or something that could have an unintended consequence. Has that had any impact from what you're seeing in your day-to-day work?
I would say absolutely. There just is. Contracts, I think, starting with GDPR and then with CCPA and now the various state privacy laws we have in place, it's almost like if you're operating without a contract in place with any of your partners, whether they're vendors or, just business partners, you're really putting yourself, you're potentially exposing yourself to liability, even in the absence of an applicable state privacy law. Because, in most cases, if you don't have a contract, it's very hard to actually enforce something, or it becomes a he said, she said, and so, yes, I think every client I work with now, at some point in our conversations, we're talking about contracts. And yes, the role of advertising technology. The contracts I deal with often are focused on that, because you're looking at, with an advertiser negotiating with an ad agency who is then going to potentially negotiate on behalf of, or try to negotiate on behalf of the advertiser with a demand side platform, et cetera, this whole alphabet soup of the ad tech entities. And you have to be on top of who is responsible for what definitions apply, what types of entities you were dealing with. You have to really hone in on those things, because the ambiguity that sometimes exists can really create downstream problems. And we saw that in the examples that you mentioned. So yeah, it's critical. And I recommend everybody at least annually, to review your contract templates to see, hey, has anything changed in the legal environment or our relationships such that we need to make updates to this at the time of the next renewal or just on an annual basis, or there's different ways of doing that. But it's a really important issue and one that people should have top of mind, because I've had clients that get requests from the California Attorney General, for instance, or the Colorado Attorney General, say, hey, I'd like to see your contracts. If your position is that, for instance, this is a service provider or a processor you're working with, let's see the contracts in place that have the quote unquote magic language that clarify that. And if you don't have that, then maybe there's an issue of deception. So just as one example of where these things come up.
In the various options that you described earlier of how companies are utilizing the ad tech ecosystem, the compliance issues are still here around notice and opt out. So, what should companies be thinking about in kind of our cookieless environment? Do I still have a cookie banner? How does the opt out work? Do I need to have something a little bit different in a notice? Just a couple different examples.
It's a great question, and one that we're going to be continuing to look at, I think, in the years ahead. I think every company's approach is going to be a little bit different, again, based on its tech stack, its B2B versus B2C nature, its general business model, volume of data collection, planned uses for it, things of this nature. But generally, I see all of this as an opportunity to engage with consumers, have good relationships, to talk to them, to get permission to notify them of what things are. Even in the absence of a privacy law applying, it's just a good practice. But you mentioned, things like, hey, compliance with notice and opt-outs, cookie banners. I think in general, it's a great question. Like, hey, in a cookieless environment, do you need to have a cookie banner? And maybe cookie banner will become a misnomer, because what you're seeing now is, even though these laws, generally speaking, do not prescribe cookie banners, sometimes they do just prescribe having, providing a notice at the point of collection. And so a lot of companies use effectively a cookie banner to provide that notice, and also to potentially get opt-in consent in some cases for the use of third-party trackers, whether they're cookies or other scripts or things like that. Because some of the laws say that if somebody instructs you or deliberately asks you to share information or provide information to a third party, then it's not a sale, and a sale requirements wouldn't attach, and things like that. And you also have, you have with global privacy control, which is recognized formally in California and Colorado, and sort of informally in some other states that allow for user-enabled technical signals to be sent that request an opt-out of the sale or sharing of their personal information. I think California incentivized friction, the use of GPC, global privacy control, which is just a browser-based signal that says, hey, opt me out of the sale or sharing of my personal information with any third party's website receiving this signal that I'm going to through my browser. You have California just, I think last week, it passed through the legislative houses to go to the governor a bill that says that would require browser providers, to build in support for basically that GPC. It's kind of like going back to the days of do not track, which didn't end up taking off because there was the absence of consensus on what signals should be used. And now we do have more consensus on signals should be used, at least under certain laws. And so California is, unless the governor vetoes it or doesn't sign or vetoes it in the next 2 weeks, I think less, that'll become a law. These things are not going away. There'll just be different technologies that you'll have to fit within the legal requirements of these laws. I just think, it's something that we're going to be looking at for each specific technology going forward. But so you don't get caught in the minutia of it, big picture, have conversations with your customers. Try to make things as logical and reasonable as possible. Don't hide the ball. Don't do secret uses of data. Be very mindful of dark patterns, because that's not going away either. And what you're seeing is a lot of state regulators and whatnot, they're much more, even if they don't have a law on the books for this, they're very inclined to use their deception powers or UDAP statutes to enforce as well. So I would say keep that in mind as you go forward.
Well said. Why are you looking at me with strange eyes?
Because I know exactly what Darren means now when he says dark patterns.
Indeed, you do.
I'm excited about that.
So happy.
Yeah.
You're so happy.
So you mentioned as in what you just said about some of these state laws, and all these state laws seem to be similar flavors, but not exactly the same. And so, how do you recommend that companies think about the guidance from, the New York AG and sell share considerations and ModPA as it relates to alternatives? And then what? What are we up to now? 19 states have privacy laws. Is that the number right now?
19 comprehensive privacy laws have been passed as of today, in September.
Pretty amazing.
I know.
So,
Crazy.
Darren, I'm an in-house counsel, and I'm thinking, Darren, I've got operations that are all over the country. How do I navigate these laws that are different? And New York and California especially are states that I have to watch out for, even if I haven't mentioned Washington, my health, my data.
Nope, that's a whole different ballgame. It's not included in the 19. That's a sectoral law.
Oh, I see. Oh, see, my mind is spinning now. So, Darren, thoughts?
Thankfully, Jody is there. Paul Jody is my first thought. Yeah, I mean, look, my first thought is on some level, yes, the walls are closing in, but on the other hand, chill, take a deep breath, chill, Justin. Everything's cool, man. Everything's cool. All right. Here's what we're going to do. Take a step back and look at the privacy program, figure out where certain state laws or international laws might apply. And you level set from that to have a general understanding of, okay, like this is big picture what I need to do, because a lot of these laws, they have common elements. They have notice, they have potentially consent, they have, high level security provisions, they have consumer rights, they have, a lot of the same things that we've been dealing with for 40, 50 years, going back to the FIPS in the 70s. And so I think sometimes it's very easy to get caught up in, oh my God, there's this multiplicity of laws. They all have tentacles, I can't do everything right to everybody. I get that. So what I usually advise companies, really of all sizes, but in particular, the non-hyper mature companies that are publicly traded and they've got 50 people looking at this, is let's get the big things in place, the low-lying fruit, the stuff that, and I say this in a non-pejorative way, a bureaucrat at a state AG's office, if they have a list of websites in front of them that they're given to check out, let's make sure that the things that they would look at are going to work here. And that may vary. You may have to tweak things based on different states, because there's amazing stuff you can do with reverse geo IP lookup to kind of infer, not be sure, but infer a state someone's coming from, et cetera. And you can tailor things in that way, in ways you couldn't, 5 or 10 years ago. So what I would say is get the big stuff right first. Get your, have a mechanism for receiving consumer privacy requests. I would say have, a privacy policy that articulates what it is you do, and follow the golden rule of doing what you say you're going to do and not doing things you don't say you're going to do. That you'd be surprised how far that will get you. If you're using third-party cookies or trackers, while we still have the current system we have in place, have a mechanism for capturing either consent or allowing people to, control their preferences in that regard. Have some trained staff, have a good, put a front face forward for people where they can contact you with questions, et cetera. Make it as engaging as possible. Like if you do those big things as part of your privacy program, then honestly, it ends up becoming tweaks for different markets rather than this impending sense of doom where you have to reinvent the wheel each time. You don't. There's going to be a lot of reusable aspects of your privacy program. So yes, there are challenges. I mean, New York is issuing guidance, as you said, on cookies and trackers in the absence of even having a comprehensive privacy law on the books that directly impacts how people can and should use trackers, in relation to New York residents. But they've said that if you don't do what we say, this could be part of our deception. You could be deceiving consumers, and that's something that the AG can enforce against. You've got Maryland coming out with a privacy law now that says that it basically restricts companies from collecting, processing, sharing sensitive data entirely, except where strictly necessary to provide or maintain a specific product or service requested by a consumer. That's a very high bar. So there are new things that are happening, and we will look at each one and advise as to if this really is meaningful in terms of the changes you need for your privacy program. But writ large, have the big stuff in place that we talked about. Certainly talk to Red Clover advisors. I know you have great materials out there that help outline these things. Get that stuff in place, and then you can deal with the minutia after. But in most cases with regulators I've worked with, and I've been on a lot of investigations, it does count a lot that you've shown privacy proactivity and you've taken steps in advance, you've done things. They'll work with you on the rest if you're off on detail.
Well, Darren, you said something interesting there that brings to mind the following thought is you've been involved in investigations from state regulators. So, what can you share with our audience, particularly general counsels who listen to this, who's never had that happen? So, if you are investigated or having a program to prepare if you were investigated, what have you learned practically when you've had to deal with those investigations that could help inform how companies go about creating their program with the eye of, hey, attorney general from state wherever may come in and audit us or have questions?
Yes, yeah, state and federal, because the Federal Trade Commission is very active in this space too in the last few years, for sure. I would say a lot of what I just said is the more you can demonstrate privacy proactivity and show that you've thought about it. You have vendor assessments to evaluate vendors, so that if the vendor has a breach, it can't just be like, well, throw our hands up. We picked them. They said they'd be fine, and they weren't. Like, no, you need to have evaluated them. You need to have contracts that limit their activities, need to have things in place. They need to notify you if they have an issue. That's one example. For other regulator matters, often it's data breaches, but sometimes it's just compliance with their new state privacy framework, and they're trying to flex their muscles to say, we are enforcing this. You've heard a lot come out of Texas, for instance, the Texas AG saying, hey, we are, our new law came into effect on July 1st in Texas, and we're not messing around. So, I think what you get from being on a lot of investigations is often they are lengthy and deliberative process, and it's a game of there's some back and forth involved. But what you end up finding is they generally don't want to go after you if you do have reasonable practices and there was like a mistake. Like, you can work with them on that. It's when you don't do anything and you don't show your work where you have a problem. So have those contracts, have those steps you can say that you can point to, have really good people within the company who are your chief information security officers and privacy counsel, have good outside advisors, et cetera. And, that's usually your halfway to happy hour in that regard.
Well, Darren, I think you just said it with 3 words, because that's what I know Jody always says, is it sounds to me like what you're saying is the key is when the regulator comes in, you have to be able to show your work, because I've seen enough companies where I'm like, well, where's your documentation? Or we're going through a cyber compliance plan, stuff that I deal with. We have to be able to document everything we're doing, because if the regulator comes in, it could be the SEC, it could be any of the ones that you named. Isn't that what they're looking for? It's not what you say, it's what you can document and show us in practice that you're doing. Is that in essence what you're meaning when you deal with the regulators?
Absolutely, because if it gets to that point, you don't want to be creating the materials then, because that's just an implicit admission that, well, we didn't have it before, but we're on it now. What they want to be able to show, even if there was a harm and you are at fault, what they want to be able to show is or what you want to be able to show is, look, it's really been mitigated or moot at this point, because we do have all these things in place from before, from after the event, and the harm has been, the risk of harm has been really mitigated. And you want to be able to document, this is all the stuff we did up front. Here's our ROPAs. Here's our assessments. Here's who we're working with. Here's the training we've had for employees. Here's our contracts with others. Here's our vendor questionnaires, things like that. And say, all right, this company is not half what. They something happened, but things always happen. That's not the question. That's not like the evaluation is whether something occurred. Things are always going to occur. It's how prepared you were for it, and then how you mitigated the risk to people. And that generally, and the same thing from a compliance standpoint. Like, maybe you missed one thing, but if your overall program is solid and you clearly are trying to, in good faith, solve for this, then that goes a long way.
And how do you see that playing out when you've seen fines or other kinds of penalties levied? Is there any way to quantify what that cost savings? Because that's what I tell people. At least if you screw up and you have all this in place, you might get fined, but it's a whole lot less than what might happen if you got bupkis and they're like, you've done nothing. Then they throw the penalty book at you.
I think that's definitely right. You save a lot in the long run by doing, by the growing pains that you have to have up front to get these things in place. And then once you have the big things in place that we've been talking about, then it's a matter of tweaking, iterating, updating, but it's not wholesale. So, you do have to invest up front, but we're talking about something that is critical for every single company from their reputational standpoint, et cetera. From if you're looking to be acquired, if you're scaling up, you want to be acquired. Like, these are the things that I can tell you. They are asked every day in mergers and acquisitions, in regulatory investigations, in a whole, board of directors, seeking outside investment, whatever it is. Like, this is just part and parcel of good business practices now, is data privacy and security hygiene. And if you're a company that doesn't emphasize that, or doesn't really care, or doesn't want to invest in it, you will be the outlier compared to your competitors, because a lot of people recognize this is a C-suite top line issue that people need to be aware of, and be able to show your work on.
Knowing what you know, especially when it comes to advertising and how companies use data, what is your best personal privacy tip that you might offer at a party or amongst your friends?
To check your apps at least annually. They often collect information even when they're running in the background, or you've long forgotten about them. So call it data minimization for yourself, but maybe on New Year's Day or something, go through the list of all the mobile applications on your phone. And if you don't need it and you haven't used it in 6 months, then maybe you can get rid of it, knowing you can always download it later. But it may be collecting information about you. And also, for that matter, check your settings, because sometimes companies that don't work with Red Clover, advisors and others, they don't always follow the best practices. Sometimes they'll update your settings or like capabilities within the settings without telling you. So do check that out and be aware of it as well. You have to be in charge of your own privacy. So, even though companies are supposed to, you need to, it's your life, it's your privacy. So be aware of your settings and update those accordingly.
I love deleting apps. It is so much fun. I truly do.
That sounds so exciting.
But I like to organize and clean. It's kind of like cleaning your desk or spring cleaning. It's so much fun. I really recommend.
Wow, that's exciting.
It is exciting. You should try it sometime.
I do delete apps.
See, it's fun.
Okay.
He's talking about eating appetizers, Jody.
Yeah, I know.
So that's what he means by delete apps.
So, Darren, when you're not advising companies on privacy, what do you like to do for fun?
Visit national parks. My wife and I took our 1-year-old son to Yellowstone this month, or I guess last month, and that was just fantastic. Seeing the hot springs and the mountains and the fields and the bison, and it was really cool. We have a national park passport, and I think this was our 21st national park, so we're just ahead of comprehensive state privacy laws, but it's getting close. So that's where we are. I follow soccer, Go Arsenal, and U.S. men's national team, and some others. And hard these days to avoid some of the political stuff going on, as we have federal elections in 2 months. So keeping track of some of that, and otherwise trying to get out in nature and raise our little hatchling, and hopefully live a good life.
That sounds really nice. I have not been to Yellowstone. On the list. One day we'll get there.
Yes.
Well, Darren,
cool.
We're so glad that you came and shared all this amazing information with us. If people would like to connect and learn more, where should they go?
They can find me on LinkedIn, Darren Abernethy, Abernethy, or the Greenberg Traurig website, or our Data Privacy Dish blog. And thank you again, Jody and Justin, for the courtesy you sent in having me. I really appreciate it. This was fun.
Our pleasure. Thank you so much.
See you guys.
Thanks for listening to the She Said Privacy, He Said Security podcast. If you haven't already, be sure to click subscribe to get future episodes and check us out on LinkedIn. See you next time.